stuff for a really long time, so she knows what's what.
Everybody ready?
Oh, has that happened? Okay.
I will go ahead and call to order. I don't think the mic on. Call to order the Executive Committee of Tippecanoe County for June 4th, 2025. Yes, thank you, Craig. And first on the agenda is the roll call.
Jackson Bogan.
Present.
Diana Looper.
Present.
Kathy Parker.
Here.
Gary Schroeder.
Present.
Larry Leverins.
Here.
Tom Murtaugh.
Present.
Jerry Reynolds.
Present. Okay, next on the agenda is approval of the minutes.
I move to approve the minutes from May 7th, 2025, public hearing as submitted.
I second it.
So we have a motion, a second, to approve the minutes. Do we have any comments or corrections? Hearing none, all those in favor say aye.
Aye.
Opposed? That motion carries. Next is new business. We have anything from the staff? Nope.
Nope, there's nothing.
Okay. Next, there are no subdivision cases, so I guess we are going to do the approval of the minutes, Jerry. Approval, I'm sorry, of the APC agenda.
I move to place USO amendments 120 and 121 on June 18th, 2025, Area Plan Commission public hearing agenda.
I second it.
All those in favor say aye.
Aye.
Opposed? That motion carries. Subdivisions.
I move to place the following subdivision petitions on June 18th, 2025, Area Plan Commission public hearing agenda at petitioner's request. Placement thereon being without reference to compliance and noncompliance with the adopted subdivision ordinance.
Do we have a second?
Second.
All
I
in
thought you
favor?
had to read the bottom.
Oh, we have more. Turn the page. Thank
Yeah, I
you.
do. I hadn't
No.
finished it.
Nope. I guess that is it. Okay. Thank you.
So, yeah.
So are we okay for the vote?
Got to read the subdivision number.
Yeah.
Okay.
Yeah. Subdivision number S5272, Bower Ridge Estates, formerly Timber Ridge Estates, major preliminary.
I second it.
Thank you for that, Diane. All those in favor say aye.
Aye.
Opposed? That motion carries.
I move the following rezone petition to be placed on June 18th, 2025, Area Plan Commission public hearing agenda. Z2966 Buckingham Properties, Nathan Harris, the Research Village, Phase 3 PD, and R1 and R3 to PDRS. Z2973 Purdue Research Foundation, Old Town Companies, Providence PD, Phase 6, PDMX to PDRS. Z2983 Purdue Research Foundation, I3 to OR, and Z2985 Andrew Stanko, R1B to R1T.
I second it.
All those in favor say aye.
Aye.
Opposed? That motion carries.
I move the following petition be placed on June 25th, 2025, Area Board of Zoning Appeals public hearing. BZA 2198, Travis and Christine Furist. BZA 2199, Rainbow Trout Solar. BZA 2200, Martin J. Kimple. And BZA 2201, Reed Washington.
I second it.
All those in favor say aye.
Aye.
Opposed? That motion carries. Now for the next case, special exception determination, rainbow trout. I'm going to recuse myself on that since I'm on the BZA, and I will hear that later this month. Okay.
Who explains the,
When?
who's supposed to explain the procedure? Are you supposed to?
Yes.
Yeah,
Patrick?
go ahead.
Generally speaking, this is not an opportunity for a public hearing at this time. We have received requests from 2 attorneys to speak, however, so an opportunity will be given for 5 minutes to each of them to speak. After that, I believe the commission staff is going to make a presentation before the body votes. So we can go ahead and proceed, I think, with the attorneys. Oh, sorry, the staff is going to go first, so I think we can go ahead and proceed with that.
I move that the following special exception request would not have to substantially adverse effect on the purpose served by the Unified Zoning Ordinance and furtherance of the comprehensive plan for the Tippecanoe County, BZA 2199 Rainbow Trout Solar LLC.
I second it.
Amanda?
Good afternoon. Amanda Esposito, Assistant Director, APC Staff. Our determination of special exception was provided in your packets. I won't go through the whole thing, but it is aiding staff's opinion for any BZA action is whether or not this action would substantially adversely affect the community's comprehensive plan. This is generally procedural, as explained. Looking at the adopted comprehensive plan at the goals, they are broken down into several different sections. One of them is public facilities and services. Goal 1, utilities as the precursor and basic determinant of development in the growth sectors should be properly timed, adequately designed, and efficiently administered for the best cost-benefit relationship. Development in their county usually follows the presence of public utilities and facilities, such as sewer, water, and public roads. The proposed development of a large-scale solar system has no such need for public infrastructure. The system itself would be providing utilities itself. The acreage included in this request also contains numerous public roads for ease of access, both during construction and while the system is up and running. So the infrastructure is being proposed as part of this project. The second section is environmental considerations, where we promote public pride and consideration for the environment, including protection of natural and scenic areas and preservation of prime agricultural land. Goal 2 is promoting only that development which is compatible with the soil type and drainage patterns. This area does have a sensitive environmental area because of the watershed from Goose Creek. There are some floodplain areas that are included within the boundaries of the special exception. Runoff from this project will not be exposed to any toxic materials that would compromise the groundwater. Furthermore, native plantings below the array that is required by ordinance would help to filter any potential contaminants found in the rainwater before it gets into the groundwater system. Topsoil is to be maintained according to the petitioner as much as possible with minimal grading in the initial development stages. Any topsoil that would need to be removed would be kept for later restoration during their decommissioning stage. Regarding preserving prime agricultural lands, this system has a lifespan of approximately 35 years. Upon its completion, it will be decommissioned. So they will take measures to restore the land back to what it had been before the solar array was there. In addition to which, the soils won't have been disturbed for the length of the lifespan. Not only will soils not have been tilled, which creates a continuous cycle of erosion, but it will be left untreated by harmful agricultural chemicals that have detrimental effects on the ecosystem. The third section from the comprehensive plan is economic growth. And the goal was to support orderly, manageable industrial and commercial development that will encourage the economic growth and well-being of Lafayette, West Lafayette, and Tippecanoe County. This solar system, large-scale solar system, is intended to generate power that will be used by any number of consumers, either in or out of the county. Locally generated renewable energy ensures that the community will be able to thrive economically in the future when non-renewables have been depleted. From an individual perspective, property owners who sign lease agreements for the use of their property for the solar energy system often make more per acre than they would have growing crops. A recent article stated leases in Indiana offered between $900 to $1,500 an acre, compared to $251 an acre from the top corn and soybean producers in 2023, and that's statewide. All of that could be spent locally. right? So furthermore, going away from the goals of the comprehensive plan and talking about some other things that might be potential disturbance for neighboring properties. Regarding noise, this large-scale solar energy system would have include 30 inverter stations and 1 substation. The inverters are no less than 250 feet from the nearest residentially occupied structure. That's approximately the height of a giant sequoia tree away from the nearest occupied structure that's not participating in the solar project. The decibels for an inverter station are less than that of a typical refrigerator. The solar energy system will not only be enclosed by a fence, but buffering is also being provided in the form of tree plantings to block any potential views of neighboring properties. And the panels are designed with anti-reflective coating. The intent is to capture the sun's rays in this solar array, not to reflect it. So based on those goals from the comprehensive plan and the proposed use of the property, staff has determined that this request will not substantially adversely affect the adopted comprehensive plan for Tippecanoe County. Thank you.
Thank you, Amanda. Opposition lawyer, 5 minutes, please.
Thank you, members of the Executive Committee, to allow me to address you with regard to the particular issue in front of you, and that is the comprehensive plan evaluation and whether you should make a recommendation.
Can we have your name, please?
That, in
Can we have a
essence-
name, please?
Pardon me?
Name, please?
Oh, I'm sorry. 1393 West Oak Street, Mike Andrioli, and that's in Zionsville, Indiana, is where my office. I represent the large group of remonstrators against the current application for a large solar array. Before I move on to that, I want to see if I can, since we weren't allowed to address the application to be put on the agenda for the June meeting, I want to, for the record, formally offer our objection to having that be placed on the agenda, for the reason that we do not believe that the application that has been submitted in this matter is complete by any means. And given the fact that it is incomplete for many reasons, we believe, we don't think that it should be appropriately put on the agenda. The other thing that's currently moving through the legislative body of the county is the fact that a moratorium has been passed on the first reading, and legitimately that should be, you should wait to determine and see what is done with regard to the adoption of that. And if I may, I'll not touch on that any further, other than to formally just offer our objection for the record in this matter, and to have 2 letters admitted having to do with our analysis as to why the application itself is not complete. And I won't touch on it any further other than to have these in the record, if I may. With regard to the comprehensive plan, we could not disagree with staff any more vehemently with regard to the determination that were made as to the comprehensive plan as to how it applied to this particular application. Interestingly, we went back through your comprehensive plan and how these things would be generally treated, and we saw that the Rogers Mining Group had been in several years ago and had to go through the process and for a mining operation, and the matrix was used, which was called for in your comprehensive plan. Ironically, we tried to work the matrix ourselves and could not find that it was supported by the comprehensive plan, this particular application. So we're not sure why the matrix wasn't used in this particular matter, but most of the argument that staff has put forth is an argument as to why it meets the requirements of the special exception or the standards that are there based upon your ordinance, not the comprehensive plan itself. Your uniform development ordinance, as it relates to the select ag classification, and this is in the select ag classification, this land, not just the agricultural classification, which has a special meaning and has special words that they've used when the comprehensive plan was developed as it relates to the preservation of farmland. And your UDO defines this, select ag, as to provide an area identified within the comprehensive plan as having either the highest potential for agricultural use. And when you look at your ordinance itself, use is highlighted by being not italicized, but it's darkened. So it's clear that the word use was intended to mean exactly that. What is the agricultural use? Either the highest potential for agricultural use when no urbanization has occurred, which are to be reserved for the wider range of agricultural activated, and the homes primarily of those engaged in such activities and their families. This is a commercial use.
Just want to let you know that you have 30 seconds.
Pardon me?
You have 30 seconds.
Okay, this is a commercial use. This is not an agricultural use. And your comprehensive plan is clear that farming is central to the local economy, and much farming has been lost. Very high productivity greatly enhances AG land use potential. There's nothing about the land itself that suggests that any use other than agricultural would be appropriate. It's not brownfields, it's not
5 minutes are
woodlands,
up.
it's high production agricultural use, and that's what should have been concentrated on. Thank you.
Thank you, sir. Petitioners, lawyer.
Yes, Ryan Munden with RTS Law here on behalf of Rainbow Trout Solar LLC. As always, thank you to APC staff for their thorough summary. With respect to what they focused on in their report, the Rogers Group matter did focus as well on the goals of the comprehensive plan, so we take no issue with the direction that staff went with their recommendation. With respect to the completeness of our application, we did receive an email from Ryan O'Gara dated Thursday, May 29th, confirming that it was a complete application. So we don't view that as an issue at this stage, especially since we're on the agenda. As staff mentions in their report, this is an extremely thoroughly vetted and closely evaluated project. We have had multiple pre-submission meetings with APC staff. Our client and our office have met with the county and APC staff on and off over the last 3 years. So this is not a project that is being slammed through at the last second by any means. We've shared drafts of our petition and site plan, received feedback from staff, and made changes and had follow-up meetings. This has been very thoroughly vetted. I'd like to also highlight, as Amanda did, the lifespan of the project at 35 years. After that, the project will be decommissioned. As a result, this is not a permanent change. Unlike a gravel mining operation, we're not leaving a giant hole that will be filled with water when the project is over. We'll return the property to the way it is now. With respect to environmental considerations, we agree with staff that the solar project will be less impactful than crop production, which involves tilling soil and application of agricultural chemicals. We're also strongly considering use of agrovoltaics, which would include sheep grazing under the panels to help control vegetation, and have been in discussions with multiple groups, including Purdue University, regarding that. With respect to economic growth, we agree with staff that promotion of renewable energy is positive for the economy, including the financial benefits of the participating landowners. And with respect to the impact on the neighbors, the majority of the concerns that we have heard, and our client has held public information meetings, is simply that they don't want to look at the project. Any new development is going to change the landscape, and as we've said, this is not a permanent change. And our application included over 700 pages of studies. And in those studies, they conclude that any change that this project does present is minimal. The studies included a preliminary drainage study, which concluded that proposed change in land use satisfies the design parameters outlined in the Indiana NPDES standards, and conversion from agricultural areas to more densely vegetated areas reduce runoff rates. A visual impact analysis concluded the results of the viewshed analysis indicate that proposed solar arrays associated with the project will be screened from view in approximately 89.93% of cases within a 5-mile radius. Noise study concluded, again, as Amanda discussed, 49 decibels, which is less than a refrigerator. Glint and glare analysis concluded that there would be no glare from the helipads at both hospitals, the Purdue Airport, the air traffic control tower at Purdue, the 16 road segments included in their analysis, and the 51 structures in the vicinity, no glare. Traffic impact study concluded, as demonstrated in the traffic analysis, the construction period will not produce significant operational changes to existing roadways. Once operational, the facility will be managed and monitored by a small number of employees, which will generate only a few trips per day. This additional volume of daily traffic is considered negligible. Economic impact analysis concluded that the solar use will result in an increase in total economic output of $15 million. The direct economic output for solar use is 15.8 times greater than the direct economic output of farm use. Solar use will significantly increase property tax revenue in the county. Solar use will generate $30.1 million in revenue for local tax jurisdictions over the life of the project. Property valuation study concluded the analysis shows no impact on home values.
30 seconds.
Due to a budding or adjoining solar project, as well as no impact to a budding or adjacent vacant residential or agricultural land where the solar project is properly screened and buffered. With respect to screening and buffering, our landscape plan that was submitted along with the over 700 pages of studies provides for 11.5 miles of planted trees and shrubs. In addition, the setback requirement in the UZO is 200 feet. We are at least 250 feet, in
5 minutes
some
are up.
cases, 1,100 feet away from structures. Thank you.
Thank you. Discussion from the committee. Jackson.
Yeah, I have a question more for you, Counselor, as to what we are doing, what our job or responsibility is here with this special exception. And I'll compare it to like a subdivision request where our job, and what's piquing this question is, made a comment on error in the application or application not being complete in a subdivision. Our job is it complete or not, and was it completed properly? And we really can't vote no. Is that what we are doing here?
Yeah, I mean, this is one of the factors that will be considered by the BZA. I mean, it'll.
So are we simply just putting this on the agenda? Our vote more than that has no other purpose than for it to be heard by the BZA?
Well, and your vote is going to be used as guidance to the BZA as to whether or not it's consistent with the comprehensive plan from your perspective.
Yeah,
Okay.
I think what Patrick said last was more accurate in
Yeah.
terms of whether it would adversely impact the comprehensive plan as opposed to whether or not the application was complete.
Yeah.
So are we clear that we may vote yes or no, or we cannot vote no? I'm just asking that question.
You can vote yes or no,
Okay.
depending on whether or not you think this is consistent with the
Consistent,
comprehensive
right.
plan, which would then go to the BZA
Okay.
as one of the factors that they'll consider.
Right, okay.
So again, for clarification, if we feel it goes against the comprehensive plan, we would want to vote no. If we feel it is in line with the comprehensive plan, we would want to vote yes.
That is accurate, correct. Yep.
Thank you.
And again, the ordinance, though, does not state that these type of projects have to be zoned commercially. It states that they're allowed in ag zones, but just require a special exception and not a rezone. Correct? Yeah.
Other comments, questions?
But council agrees that the application is complete, you know.
I think that is, I can only defer to, I'll defer to staff. I'm not involved in that.
Based on Ryan O'Gara's email to the question, We do believe that the filing is complete, but we are, of course, always open to reevaluation if necessary.
So, all right, I'm sorry. One more point. So our current ordinance says that it is allowed, but requires a special exception.
Correct.
That is correct.
Okay. And our job is to determine whether the comprehensive plan / ordinance, if that's what it says. Okay.
With exception.
Right, but we're not the ones making the exception.
Yeah, okay.
Okay, any other comments, questions? All right, just to clarify, if you vote, if you're voting yes, you're voting that the solar farm will not adversely affect the comprehensive plan. Everyone clear? Okay, you have a yellow ballot.
Oh, I'm sorry.
We have 5 yes votes and 1 no vote.
Okay. Nathan, would you grab Gary or who?
Yeah, Larry,
Yes.
that simply means it will be heard at the BZA meeting on June 25th, right?
Right. And they will make
They will give the thumbs up or the thumbs down.
to the special exception. Yes.
Thank you. I just wanted to say that for everybody.
Thank you.
Where are we?
Right, determine variances.
Okay, determination of variances, Jerry.
I move the following requests for variance from the Unified Zoning Ordinance are not requests for use variance as prohibited from consideration by the ordinance and statute. 2025-10 KBC Investments LLC, 2025-11 Neil Clemmy, and 2025-12
Crit Paul Gotha.
Gathara?
Yeah,
Gathara?
Gotha.
Okay.
I second it.
All those in favor say aye.
Aye.
Opposed, that motion carries. May budget report, Jerry.
I move we approve the May 2025 budget report as submitted.
I second it.
Amanda.
Happy to try to answer any questions if you have them.
Okay, any questions from the commission? No. All those in favor say aye.
Aye.
Opposed, that motion carries. Any other business? Nope. We'll adjourn and we're going to start the ordinance committee, ordinance and bylaw committee. So I will call to order the Area Plan Commission of Tippecanoe County Ordinance and Bylaw Committee for June 4th, 2025. And first on the agenda is approval of the minutes. Someone?
I move to approve the minutes from the May 7th, 2025 meeting.
Second.
So a motion is second. Any questions or corrections? Hearing none, all those in favor say aye.
Aye.
Opposed, that motion carries. I kind of stopped. Did we welcome our guest yet? Our
No, I
guest? I noticed we had a lot of people here in red. I didn't know if are those IU grads that you know? Yes, so we have some IU grads, so welcome, all the people in red. Jackson wanted me to recognize you there. Okay,
as a fellow IU grad.
yes, absolutely. Okay. Second, manufactured homes in Clarks Hill.
good evening. The town of Clarks Hill passed a resolution asking the Area Plan Commission staff to look at mobile homes and manufactured homes specifically within the town. Mobile homes, manufactured homes are a very simple definition. I'll read it. A single dwelling suitable for year-round occupancy, transportable in one or more sections, built on a permanent chassis and designed to be used with or without a permanent foundation. I think we're all familiar with them. The zoning ordinance currently allows these just in the rural zones. The permitted use table has a footnote that says only in the unincorporated county. What staff is proposing to do is change that footnote to address Clarks Hill's wishes so that it would now say, permitted in unincorporated Tippecanoe County, however, within the incorporated town of Clarks Hill, with the permission from the town board, manufactured homes and mobile homes shall be permitted by right in all single-family zones within the town. So the town wanted the authority to look at these project by project. So staff has come up with this amendment to address this. I'd be happy to answer any questions if you have any.
Very good. That's just something you're going to work on.
Yes.
Okay.
Yeah, we haven't filed an amendment yet.
Okay, very good. Thank you. Anybody from the audience want to comment on this? Questions or comments from the staff? Hearing none, I guess we'll just move. It's on the agenda for June. Okay, thank you for that. So, hearing none, I guess we'll just hear that at the APC in June. Okay. Do you need a recommendation from us to send that on?
I think that would be preferable.
Okay, I
If you don't
take that
mind.
motion to send that on with a positive recommendation.
I move. So moved.
So I have a motion, and somebody will second that? Second. So Jackson, second. Now, any other questions or comments about that? Hearing none, all those in favor say aye.
Aye.
Opposed? That motion carries. Boarding kennels.
All right, so this is a bit of a, cleanup, no-brainer amendment to our ordinance for boarding kennels in commercial zones. Right now, the ordinance divides them between commercial zones and rural zones in our Special Conditions, Chapter 4. In commercial zones, it currently prohibits runs, exercise yards, or other facilities for boarding animals in any exterior space. We all agreed at our recent administrative officers meeting that providing these outdoor spaces is kind of a necessary part of the use for the humane treatment of animals, obviously. Within city limits, there are numerous boarding kennels that already have outdoor areas. So we're just trying to make sure that future boarding kennels that want to locate in commercial areas are allowed to have these outdoor areas. So we're proposing just deleting the runs, exercise yards, or other from that first point in the chapter. And then also adding a note that rural, so the first section of this Chapter 411.3 is for the commercial. What follows is the one for rural that you're not seeing here. But rural does include a caveat that exterior areas have to be fenced. We're adding that to the commercial areas as well so that they both match, requiring a fence capable of confining the animals in those outdoor areas. So again, we're recommending approval for this. We have already advertised for it so that it can also go to APC this month if you guys are amenable to that.
Very good. Thank you, Amanda. Anyone from the audience wish to comment on this? Questions or comments from the commission? I guess we'll take a motion to move that on to the full commission.
So moved.
Second.
So a motion is second to send it to the full commission to be heard this month with a positive recommendation. Any other comments? Hearing none. All those in favor say aye.
Aye.
Opposed? That motion carries. Now, rezone prime farmland in Wabash and Tippecanoe Townships.
All right, so we're back here again at your request from last month. The memo that was included in your packet has a bit of a recap of all the points that were addressed at last month's meeting. I won't go through all of that. A couple of newer items that I wanted to make sure I called attention to. We did receive 6 envelopes undeliverable from some of the property owners without having any additional information about who they are and how to contact them. We're not able to follow up on that. We did check to see if any of those property owners owned other property in the county. Perhaps those properties had a different mailing address. No, this was the only property that those property owners owned, according to our Beacon records, so we weren't able to go down that pathway for them. What staff is recommending, what we included in the memo as well, was our best version of a draft letter. If a second letter is indeed something that we think is the best option, we did our best to explain why property owners would be getting a second notice, what their rights are as property owners, what it means to stay in the rezone, that they don't have to contact us if they want to stay in, that if they want to opt out, that they should contact us, what it means for both staying in or opting out. Included in this letter, if we decide to send it, would also be the handy permitted use table that we created that shows the difference between A and AA zoning. And we're happy to, talk about any edits or suggestions or anything else that you guys want to talk about regarding this rezone.
Okay.
Thank you.
I'll ask the commission first. Any questions or comments from the commission on this?
So, just reviewing the letter, so does staff think it's too late to have to do the opt-in versus opt-out?
I think that would be just ultimately very
Very
confusing to
confusing.
people, saying that, wait, now I have to contact APC? What happened if I already opted out? Do I need to do anything in that case? I think it ultimately would be too late and too confusing to do that.
And how many folks have opted out?
At this point, we have removed 29 individual property ID numbers. That's from about, what did I say? I wrote it down somewhere here. Here we go. We've gotten 18 total contacts. I think 15 or 16 people opted out for their various property ID numbers. Out of 159, yeah.
And the 6, did you say you had 6 that you can't reach, that where the letter was returned?
6 that we were not able to reach,
Do
correct.
those seem to be, were those mailing addresses outside of Tippecanoe County?
I could check them really quick. I don't remember.
Or were they corporations, like,
It was a mix,
was it?
yeah. Individual owners and companies. It's the one with the paper standing up. It's inside the brown folder.
I mean, ultimately, I think we might want to consider, at least for those 6, removing them from consideration. I really don't like the idea of rezoning somebody's property that we can't.
Good idea.
If they wanted to rezone at some point in the future, it would be on them to petition us with the fee of $500 and everything.
Any other comments?
Yet, do we ever see a situation, and I'm asking you to look into a crystal ball, to where someone would come to us and that has it currently zoned A, because that's what it is today, request it to be zoned to AA, and we say no? Or the recommendation is no?
You're asking if APC would ever
Yeah, would
recommend
we,
no?
of the land that we're talking about,
Yeah.
I guess going back to Commissioner Murtaugh's point about the opting into AA versus, I'm wondering, would we ever have a situation where we wouldn't grant it, even if they weren't notified, didn't know about it, forgotten, and they're like,
I
oh
don't-
gosh, I'd like to be a part of that?
No, I don't believe so, because our adopted comprehensive plan recommends AA for these areas, so we would likely be able to support that.
So have we ever had an individual come in and ask to have their property zoned from A to AA? Not that I can ever think of.
No, I think AA has always been the domain of APC, trying to follow up on what the public has told us at all of our meetings when we do these comprehensive land use updates. They want to preserve their farmland. So AA is our answer to that, and rezoning to AA follows up with that comprehensive land use recommendation.
What do we want to change it?
But from the responses that we've received a far greater number of people opting out of it than saying they wanted to be in it, right? Or is that tough to?
Yes, that is true. The people who have not responded to us, we don't know how they feel.
Right.
That is the case with most. Being a member of the public government here, we often only hear from people who are opposed to something. That is the case with most petitions. If they're okay with it, we often don't hear from people.
Is there a time frame that you want to have this done by?
We would like to take this forward within the next few months. Last month, you all recommended continuing the APC rezone to August. So we'd like to stick to that time frame if possible, but it's ultimately up to you.
I have a couple comments about the first meeting we had from Otto During. If those of you who know him know he's been in agriculture for a long time and supports farmland remaining farmland. However, he said he would be opting out because his parcels look like they would be a dam against future development. And I think that's my thought, is we should be planning for growth, not planning to stop growth. And it's hard to predict what's going to happen the next 10, 20, 30 years. It looks like some of that is already up against developed ground that may be served by utilities. And I'm not sure that that's really what we want to do. And as another person spoke, that, he just wanted to do what he wanted to do with his own property. And we already have a governmental agency, United States Department of Agriculture, that has a lot of programs for farmers that either want to, most of it's erosion control or keeping farm. They have programs where they pay people to get in those programs. So farmers are well aware of that. I just think making a large swath of AA, which is going to be hard to develop maybe in the foreseeable future, is not something that we want to do unless those people want to. And of course, as long as they own the land, they can do whatever they want. And we see that already. People don't want to sell their land. They want to farm it until it's time to be developed.
Can you, just as a question here, AA, I could still rezone it, right?
Yeah, absolutely.
I'm not sure I get entirely what the protection is.
It's a little bit more difficult to go from AA to one of the development zones. You look at it a little bit more closely, like, is it really possible for this property to have development on it?
I think a good example might be of an accommodation rezone where, let's say we have a property rurally located that wants to have some type of commercial zoning. And I think if it were zoned A and going to GB, that may be a different argument than AA, where staff would do an analysis of the land use, of what the best land use is to a commercial zone. So in that respect, Larry, I think that, like Amanda said, it gives us another reason to look at it more carefully to say, well, what is the intent of the AA, and is that serving this property well, versus the proposed commercial zone, versus just A zoning in a commercial zone. We may not be honing in on the productivity of the soils as much as we would be if it were zoned AA.
Okay, you're talking about going to a GB. How about
Sure.
to an R1?
Sure, same thing.
Same thing?
Same.
Okay.
Any development zone, anything
Okay.
that's a non-rural zone that you would go to from an AA or AA, I think we would look at it that way.
Okay.
I wanted to briefly bring up what we call ag transition. We don't have a zoning classification for this land use, but it was introduced in our Wabash Tippy plan. It's those areas just outside of what's currently developed that we think is likely going to be developed in the next 10 to 15 years. Those were identified. They're not, unfortunately, shown on the map here, but they are generally around the developed areas. So we do call out those areas that could go to development in the next 10 to 15 years, and we are not including them in our rezone.
So none of those properties are on this map?
Correct. I mean, they might be shown here, but they're not included in the rezone. They're not in the black border. They might be, for example, this property right here might be classified as ag transition in the plan, or some of these properties along Morehouse might be classified as ag transition. I can't say for sure, not having that map in front of me right now, but that's what we were our intent was, or that was the intent of the plan, was to show that these are in transition. They might be farmed for the next 10 years or so, but at some point, it's very likely that they're going to see development.
Is there anyone in the audience that wanted to speak to this? There is, okay. And then we'll come back and we can talk about it more. So I did want to take some input, give some more thoughts here. Thank you.
I'll be quick. I'm
No,
going to
you're
read
fine.
a letter that I'll give to you afterwards.
Okay.
It's one page. So, dear Commissioners, I urge you to reject the APC recommendation to rezone significant portions of Wabash and Tippecanoe Townships from A, agriculture, and NB, neighborhood business, to AA, agricultural select. This proposal, based on a survey of fewer than 200 residents, less than 0.1% of the Tippecanoe County population of over 187,000, effectively constitutes condemnation without compensation. By denying landowners the highest and best use of their property, it also ignores the region's rapid growth, as evidenced in the S-Line Contractors Survey, May 23rd, 2025, which ranks West Lafayette as the nation's fastest growing metro. The S-Line study found 630 new housing permits per 100,000 people, far surpassing any other U.S. metro, reflecting high demand for residential and commercial development in northwest Wabash and Tippecanoe townships. Rezoning to AA could slash property values by 50 to 70% in cases in these high-growth areas, as seen in comparable Indiana cases, without compensating owners for lost development potential. This constitutes a regulatory taking under the Fifth Amendment in the Indiana Constitution, Article 1, Section 21, as clarified in State v. Kimco of Evansville and the U.S. Supreme Court's Lucas versus South Carolina. I've got it in there. Further supports that such significant value reduction, especially in a booming market, may be compensable. In addition, the US 231 extension to I-65 will be going through some of the proposed AA areas, resulting in definite condemnation along the new route for the road and supporting infrastructure. The rezone will depress the condemnation values for the affected property owners who won't have use of their land taken for any purpose, but future condemnation is coming, and this rezone will affect those property values. The APC's reliance on a survey with fewer than 200 participants undermines the proposal's legitimacy. The APC also failed to adequately study population growth in northwest areas, despite projections of Tippecanoe County reaching 250,000 by 2040. The oversight risks exacerbating housing shortages and stifling economic vitality, as flexible A and NB zoning supports jobs and tax revenue, as seen in nearby Boone County and other Indiana counties. Landowners can preserve farmland voluntarily through conservation easements or trust, making AA zoning unnecessary. The proposal also removes NB zoning, eliminating small businesses' opportunities critical for rural economies. By denying owners the ability to pursue market-driven uses like housing and commercial projects, the rezoning violates property rights and investment expectations in a region primed for growth. I respectfully request that you reject this proposed AA rezoning. The current proposal risks legal challenges and economic harm, undermining Tippecanoe County's future as a thriving and growing community. Thank you.
Thank you. Anyone else wishing to speak to this?
Could you please?
Oh, yeah, I'm sorry. Thank you. Yes. Kelly?
I am Kelly Bush.
Yes.
724 Northridge Drive.
Yes, I knew. Thank you. Thanks, Jackson. Anyone else wishing to speak to this? Back to the commission, and I was hoping we'd have some farmers speak because maybe Vicki can help, but soil maps don't, in my opinion, don't mean what they used to mean with farming technologies today. And just because you have good soils doesn't mean it grows good crops. It has to do with drainage, a lot of other issues. So I don't think Select Ag is what it used to be. You can grow a lot of crops on what we used to call marginal land or not your topsoils. So I'm not sure that it's as necessary as it used to be. And I think we're going to hear this again next month at the Ordinance Committee.
Yes, and if there's something in particular that you all wanted us,
Okay.
Yeah, I'm not a huge fan of it the way it's currently written. I don't know any other way to say it. So I'd like to put for discussion, recommend for discussion for the reason of, number one, not handcuffing for future growth with what we have going on and future need. And a couple options, one for discussion is either one, change it to an opt-in, or two, scrap it.
Okay, for next meeting's agenda. Okay.
I mean, if it does move forward, I do think we need to send it a second letter, definitely. But at this point, I would propose we take Jackson's suggestion, continue the discussion till next month, and then decide at that point whether to send a letter, that
Okay.
second letter.
Okay, so if we have any more, see if we have any more input then. Any other comments before we move on?
I just had a
Vicki?
question about the fee that was listed in the letter, because are we always going, let's assume we move forward with this. Is this something that's always gonna be honored, or should that fee just say for a fee and leave it at that? Because fees change, and that's just a minimal thing, but.
Yeah, I see what you're saying. Let's say a fee's of now $1,000 in 5 years. Yeah, I got it. Good point. I'm not sure they have an answer, but
yeah, we could scratch that if, yeah, that's not a problem.
maybe you say for the rezoning fee.
Yeah.
Any other comments? Okay, with those comments, we'll hear that again next ordinance committee meeting. Okay, next on the agenda, solar energy systems. Staff have anything, or are we just going to take public input?
We had nothing to present for this.
Okay, says a group of citizens requesting time, please.
Kenny McClary, 942 Chepstow Lane, West Lafayette, Indiana. Thank you for the chance to speak about the need for revisions to current utility scale solar ordinances in the county. As you know, this is a topic also behind the commissioner's plan to put an interim moratorium in place to allow for these types of revisions. I'll keep my comments focused on the areas where large-scale ordinance changes have been made in other counties within Indiana recently. Some of those are as a result of the observed and now well-recognized negative impacts that these large-scale facilities have created in their jurisdictions. And in other counties, these have been proactive efforts to get ahead of those detrimental impacts and put the right kinds of guardrails in place to protect all involved from the negative impacts of large-scale solar. It's also a recognition in some of these counties that have existing facilities to limit further damage that's caused by these negative impacts, the broken promises, and the empty claims that many solar developers have put forward in justifying those projects and their approvals. Indiana counties across the state are taking similar actions. They're recognizing there's a big difference between modest solar facility sizes and uses on commercial, industrial, and small ag land than these very, very large 1,000, 2,000, 3,000, and even 13,000 acre size facilities. 12 areas I'll mention very quickly. The first and the most important is how close is too close. Counties are increasing the sizes of their setbacks and buffer yards significantly to recognize that there are negative economic impacts on residences and adjacent properties and adjacent farm owners due to these facilities. The growing amount of evidence now around the reduction in home values when you have a property that is surrounded by two, 3, or 4 sides by a solar facility is going to be catastrophic for that homeowner. I provide you 3 examples here. Warren County, Huntington County, and Wabash County have all increased their initial setback distances to 1,320 feet. Just to remind you, our current setback is 50 feet with buffer yards of 200 feet. So those actions are taken because there's a recognition that there is a distance where it is too close to those adjacent property owners and negatively affecting their economic welfare. Second is putting limits on the maximum size of utility scale facilities. Counties are recognizing that there's a correlation between the size of these and all the problems that they create, whether that be draining, economic impacts, agricultural impacts, and also environmental. We currently don't have a cap in our ordinances on how large could a solar facility be. So many counties are putting those caps in place. Carroll County, for instance, has put a 200-acre limit on utility scale solar because they recognize that many of the issues such as drainage controls are directly tied to size. Third, their counties are putting limits in place on how much agricultural land can be used for utility scale solar. Counties have put these in place because they have competing land needs, and they do not want to see huge quantities of ground, huge chunks tied to a 40-year commitment, and therefore be unavailable for other developmental needs within the counties. Of course, this varies from county to county depending on their land use competitions that they have to balance. It's also being driven, though, by a desire to limit the loss of farm services income in a number of these counties. 800 residents in Tippecanoe County make their living with farm services, all the support that's necessary to grow crops in our county. So these limits on total farm use are also driven by limiting the negative impact of lost jobs, lost farm income, and lost services income that's associated whenever we do take ground out of agricultural use. These ordinance changes in other counties are also looking to prevent the damage the solar facilities cause during their construction period. These facilities are so large, involve so much of an influx of equipment, facilities, earth moving, and use of county road systems that additional controls are being put in place to not only further constrain that construction, such as things as noise during construction, dust generation, and destruction to county roads, but also to put limits in place for the non-seasonal activities. In other words, enforce the frost laws where they exist, enforce the existing load limits on county roads where they exist. Next are the areas that counties are focusing on are battery energy storage facilities. These are a totally unique class of type of compound that counties are struggling with. Imagine, if you will, for a minute, a 500 megawatt hour battery storage facility. That's equivalent to over 5,500 Tesla cars packed into a fairly small area. We've all seen the videos of what happened when one Tesla car catches on fire. Imagine a facility that's the equivalent of 5,500 of those battery systems in one place. Counties are struggling with this one. The health risk, the occupancy risk, the adjacent nearby properties. Because with BESS facilities, you measure setbacks in miles, not in feet, due to the severe downwind impacts and the safety risks. So for now, many counties are putting restrictions or bans in place on battery storage facilities until they can figure out where you can safely site these and how you can have emergency response and protect environmental protections in place for such an location. They're putting changes in place to protect county infrastructure, particularly drainage systems. The process of installing these very large battery and solar facilities has caused severe damage on stormwater protection systems, county infrastructure, county drain systems. And so additional controls and tightening of the drainage plans and drainage ordinances within those counties are being put in place. You know, Gary, I heard earlier that, you know, good crops need good drainage. Part of those ordinance changes are also driven by the fact that this damage has got to be restored. For that ground to be able to go back into productive farm use someday, any day, the damage that's done during the construction and the demolition of these very large facilities has to have a remedy. Otherwise, those grounds will not be properly drained to go back into farming use. Decommissioning plans are being changed. There's a recognition that decommissioning plan checklists, one like we have here today, are inadequate in covering all the costs that are now foreseen or known to happen during the decommissioning phase.
Question for you.
Yep.
I assume you're speaking for a lot of people.
I am.
I'll let you go past the 5 minutes,
Yep.
so we'll let you do that. Okay.
Yeah, and I will be speaking for several. So many counties now have ordinances in place to deal with reconstruction and decommissioning 5 to 7 feet down, not just the surface activities, but also the subsurface activities that need to be involved. Agrivoltaics are changes as well to get away from some of the unrealistic sheep grazing type of examples to something more practical and more sustainable. We're fortunate. Purdue Research actually is doing agrivoltaic research to get the more practical and more common sense applications where agriculture and solar can coexist. And finally, they're establishing ordinance requirements that during the 40-year life of these facilities, that these operations will not turn into public nuisances, public safety concerns, environmental liabilities, or hazards due to weather conditions. Many examples you can now see where weather conditions have caused adverse impacts. So ordinances are being put in place to ensure that over that 40-year lifespan, we do not end up in this county with a facility that's either abandoned or no longer functional, which either the county or the property owners have to deal with the proper cleanup and disposal. That's all I wanted to cover with you today as the main categories as we think about solar ordinances. These all come from existing Indiana counties, changes and modifications they have made. I hope we have a similar effort here and a collaborative group to form them also to prevent the kinds of harms that our current ordinances are inadequate to protect us against. Thank you.
Very good, thank you. Is there anyone else wishing to speak?
So Mike Andreoli, 1393 West Oak Street, Zionsville, represent the remonstrance group against a current petition. As I shared with the commissioners during the a meeting that they had where they adopted on first reading the moratorium, that they were not alone in this endeavor throughout the state of Indiana. As more and more literature is developed, as more and more information comes forth about solar arrays, especially the large solar arrays, communities throughout the state have been revising their ordinances, substantially revising their ordinances, and there is a plethora of proposed and adopted ordinances throughout various counties through the state that the Plan Commission and the commissioners may be able to utilize, establish their own standards, utilize what's already been done. I think it is our group's hope that the governing bodies as well as the administrative bodies will begin to understand what so many counties have understood throughout the state of Indiana in the last 2 or 3 years, is that solar arrays are the least efficient production of energy, that there's cost-benefit analysis connected with all of this. While there's an opportunity and a suggestion by the developers that that it will create energy for the grid. There's loss of productive farmland, and that cost-benefit analysis should have some type of reasonable standards by which to be able to analyze that as these projects come forth. So I think when I mentioned that it's the least productive energy, and that's why it's raised its head in so many of these counties with the empirical studies that are now out there, it's a very interesting analysis because you have substantial amounts of federal subsidies, billions and billions of federal subsidies that have been thrown at renewable energies, in particular solar arrays. But what you will find with the studies and what you will find that other counties have found considering these issues is that no matter how much federal dollars are thrown at this to try to establish it, and by the way, there's plenty of people out there that want to spend the federal dollars that are being allocated to this. No matter how much money is thrown at this, what they can't change by money alone is they can't change the climate in the state of Indiana. We are not the sunniest state in the union, and so when I suggest to you that these analyses have to be made and have been made throughout the state, it's been done with the recognition that these are not efficient technologies and that they gobble up productive farmland and are the least efficient way to go ahead and produce energy, because our climate in Indiana is what it is, and federal dollars and the billions will not change our climate structure here in the state of Indiana. So we look forward to helping with input as best we can, to help educate as best we can, so that you can do the best job you can from an ordinance standpoint. The other thing I would want to mention just briefly is that kind of hidden within this application is and not specifically talking about that application any further, but specifically within it is a battery facility of some dimension, and I think Kenny explained that to you and tried to point that out. Having represented a large group over in Kokomo where a large battery storage company was being proposed, the literature that we were able to generate and the studies and the information show that these have high volatility with regard to fire. They're difficult to fight, they're difficult to put out, and the information is out there that you can look for yourself to see that the number of fires that we've had throughout the country that have been so difficult with evacuations and large-scale evacuations surrounding these particular issues because of the toxicity of these fires and the volatility of the fires, and more importantly, the inability of the local fire departments to be able to go ahead and deal with that. So hopefully when you're looking at ordinance changes or revisions, the BESS and the battery storage would be something that you might want to consider. Thank you.
Very good.
Thank
you. Anyone else wishing to speak to this issue? And we gave the first speaker a lot of time, so I'm going to kind of keep these to 5 minutes if we can. So go ahead.
I'll be quicker than that, I promise. So I'll talk sort of technically to what you have on the books right now, which is a little bit different than what other people have talked about in terms of theoretically, where could we take this? And I talked to you about what's on the books right now through the lens of I'm an attorney. I am not representing this group of folks, though everybody standing as neighbors affected by the current project, so that's why they're all in red and they're all here, I'll say that. But, you know, I've had experience working on drafting laws, both in law school and in my current job. And I totally understand that it's a difficult thing to do, especially when you're doing it for the very first time. So in 2020, 2021, that was the first time that this county was trying to put something on the books for solar, and that's a big undertaking. And so we look at what we have produced, and it's like, okay, well, first of all, if we're just going to change only a tiny bit, there's a typo. So let's fix the typo, right? Let's get that out of there so it reads like it makes sense. But I think one of the bigger things we have going on then is we see our first application coming through the county using the ordinance. So finally, we're moving from this hypothetical world to the real world. And how does this thing function? And I think immediately we're seeing there's some divergent views on how the text of this ordinance, which is pretty succinct, it's a short part of a 100-page UZO, even works. So that's probably something that, you know, when we go back and start to take a look again, we need to make that tighter. We need to make it clearer for folks so that we don't have to have legal battles about, is the dang application even good for review? We know, right? We have a checklist in the ordinance, everybody understands how to follow it. I think that that's a pretty manageable thing, just even within the confines of only the restrictions that you already have in place on the books. But the reason that I think confusion is occurring is because you can do commercial solar in the county as a permitted use on I-1 through I-3 land. You would do that only by submitting for an ILP. You can also do it as a permitted use on AAA and AW land, not permitted, sorry, by special exception. And so you need to do the special exception application, and then you would move to an ILP phase for some of the more technical aspects of the project. But right now, the way that you have the ordinance drafted, both permitted and special exception use are in the same section of the ordinance with the same list of items that need to be in the application. And so people are saying, wait, do we submit all of these things right now to the special exception? Do we do some of them later as a part of the ILP process? Well, we know what normally informally this county would do, but we really don't know what to do right now with this particular material that's in front of us. So I think even when you just look at not taking everybody's ideology about what would be the best model to protect me at my house, there are a lot of changes that can be made to improve things, right? But then I would also encourage you to go beyond the hypothetical in the sense that when you were just taking a first crack at it, you didn't really know what these things looked like. There weren't many of them in the state. There are big solar projects in the state of Indiana now, as large as 13 to 16,000 acres. So you can drive an hour or less and you can see a really big installation. And I think once you see it, and you see it next to people's homes, and you think about what would it be like if this was coming to my front yard, you might start to feel a little bit differently about how should I regulate this, which sort of leads to my final point about it being a special exception use in our county technically can be this large industrial development on AA land. But we've been hearing from this rezone that we're talking about tonight that AA land is meant to preserve for agricultural activities, and we don't want there to be development, and we sort of want to save that in case we do need it for housing later. You know, there's a lot of positive attributes associated with AA, and so you've got people living by AA that are thinking, okay, that's what the comprehensive plan says about it. That's what the UZO says by definition about AA, but all of a sudden I have something coming next to my house that looks like a prison and functions like XL Energy up in Minnesota. I mean, this thing is huge, and it's loud, and it's nothing like a crop. So maybe we also have accidentally put something into the current ordinance that wasn't intended or envisioned. We might not have thought thousands of acres at a time were going to go to this particular use. And when you start to put those glasses on and you step back and you say, okay, if I live next to AA land in a rural area of the county, would I have ever expected this to happen? And does it make sense that this is happening here? Is this really the use that we want? Is this going to help us with the other goals of the comprehensive plan or not?
You have 30 seconds.
That's basically it for me. So if you have questions for me, I'll take them, but that's sort of my high level. I've looked at the ordinance, I've gotten really in the weeds, I'm a technician on this stuff. So, you know, anywhere during the process, I'd be glad to help, of course, or answer questions now.
Very good. Did you give us your name and address?
No, I'll write it down now though, but Catherine Sobiorski and 938 Chepstow Lane.
Okay, yeah. Okay. Thank you. Anyone else wishing to give us input on this issue? Oh, sorry. Anyone else, please come forward for input.
My name's Phil Farrar. I live at 491 Kerber Road out here where this solar farm's going in that has rainbow trout. I fished out there, never caught one, but here I really don't have a whole lot to say on the technical parts of the solar field. Outside, I know what they are. I've worked on them. I've been around them. It's dusty. There's heavy equipment. It's not pretty. The land does not look the same when they're done. No matter what they say, it's not true. Went on vacation to Tennessee here a couple weeks ago. Beautiful down there. Still can't figure out how they have no property tax, but they have the best roads I've ever driven on compared to us. Coming back, passed through Kentucky, went through Lexington, seen all the horses. We got horses ourselves. We got 10 of them. And then we get into Indiana and we see all this. It doesn't look like the place I grew up. It's starting to look like an industrial wasteland. Because as we're driving, you start seeing these shiny things in the field that they say are anti-glare. They're solar farms. And then the farther north you go, you see these big ugly monstrosities just twirling around in the sky. And I just don't want Tippecanoe County to sell its soul of what it is compared, to some of these other places. I think Tippecanoe County is unique in the fact that we have Purdue University, and they do enough crazy things there. We don't need anybody else coming in here. And, but that little place out there where we live, it's Indian Hills, what it's been called ever since I've been out there. I was born in '68, home hospital. From here, been here, gonna stay here, maybe. But it's almost like Little Brown County. That's the only spot, it seems like, in this county is like west and southwest Tippecanoe County. It's unique because it's hilly, it's not flat, it doesn't have city on it, it's just rural. And I'd be ashamed of the county if they let stuff like this go through and take away what we are, our uniqueness. Because you got these other counties that are all selling their souls for tax money and all this promised revenue that's going to come in, and it's not going to come in. And in 30, 40 years, 98% of all of us in here ain't going to be here. So I think why we are here, we need to enjoy what we have. Let's not tear it up for imaginary promises and stuff that's not going to come true. But I don't know. That's all I have to say. I just wanted to let you guys know.
Very good. Thank you, Phil. If you just sign in there. Anyone else, please come forward.
Good afternoon. My name is Steve Shelby. I'm at 9131 West, 125 North. I am not an attorney, but I have a question, or I guess comment for legal counsel maybe. In regards to decommissioning, who evaluates the financial strength of the eventual entity that owns the solar farm?
This is not a question and answer session, so if you
All
have a
right,
comment.
I'll make it a rhetorical question then, I guess.
If you want to make your comment, go ahead.
Well, I guess that's a rhetorical question or a comment. I think that's something we need to consider, that the eventual entity that owns this, from a financial strength point of view, is very important. Whether it's 10, 20, 30 years or whatever it might be, we got to remember that the companies out there, if they're not financially strong, they can't afford the decommission. So what's interesting to me, I guess, is not only is it a company that's coming in that's a solar developer, but they're also foreign owned. They're a German company. So from that standpoint, a foreign company can kind of walk away. Now, as the gentleman just made the comment, in 30 to 35 years, few of us will be here. I get that. But I think that's something that is very important. In a prior life, I was a banker, and bankers have to evaluate the financial strength of a company. And the financial strength that we would evaluate of a borrower would be 1 year, 2 years, 3 years, ongoing. So I'll continue with the rhetorical question. Someone's got to be responsible for evaluating the financial liability of whoever's going to own this farm, as well as the decommissioning. I think that's something that should be held in pretty high regard. Whether it's the APC folks, don't know. I'm curious about the liability. The other thing that's important, I think, in this is there is a county ditch that runs through this that has to do with drainage, which has been brought up time and time again, I know. But who is responsible from a financial standpoint for the flooding, for the loss of crops? Not from the area that's being developed into the solar farm, but for the surrounding areas. That's something to think about. My last comment is about the battery storage units. If you've ever been around lithium, when it explodes, you would be quite remiss if you didn't object to this. Lithium can be strewing out of a battery, and you don't put a lithium fire out with water. If you do that, it just spreads it. So from a safety standpoint, these battery storage units that are being talked about, 5,500 Teslas, that's a big area. And to put that fire out and to get access to that area is a big issue. Thank you.
Thank you, Steve. Anyone else wishing to comment on this? Anyone? Questions or comments from the commission?
So I think the intent of the moratorium was to look at the actual ordinance itself. I mean, Catherine was right in her comments. You know, we put this together and, you know, during the COVID days, and, you know, we were begging folks for comment. And because there wasn't a project on the horizon, we got very little public input. And we thought we did a decent job on it. And, you know, basically we did recognize there are some things we should be reviewing at least. So I think that's the intent, to look at the ordinance and propose some changes / revisions. Typically, you know, I think this committee would just ask staff to work on something and bring it forth. I think this might need a little bit more than that. I think we might need to put together a committee of folks, you know, that have expertise and so on and so forth. It can't be all folks who are opposed to the project. But, you know, I think, but I would ask that we have APC lead that effort. And, you know, we do have a year, you know, before, you know, we have to come forth. So it's something that we can take our time and do diligently to have several meetings set up. And so maybe that would be a subcommittee of this committee, as well as members from the general public and APC staff.
Very good. Good thought, Tom. Any other comments? Hearing none. Citizens' comments. I don't think there's any action we need to take on that. I think we got a year to address that. We got some other things to work on, but we'll get it in there. I guess I agree with what you said. We wrote that. It was a new technology. We did the same thing for wind towers. We wrote that, spent a lot of time, and ultimately decided that we did not want wind farms just because they're a roadblock to development. So as we grow,
So I'll work with APC staff, if that's okay, to try to put together a group.
Okay.
Yeah.
Very good. Thank you, Tom. Any other citizens' comments on any issue?
I have one that I want to
Just
make for the
name
record.
and address again for the
Name and
record.
address. So Catherine Sobiorowski, 938 Chepstow. And here's my comment for the record. You heard a little bit of a mention tonight about the Rogers Group mining special exception in 2017. And I also saw a bit of confusion, I think, tonight on, well, why are these folks really here? Why do we have people speaking about a determination report? Like, where is this headed? What is our role in this? I've been really in your UZO lately. If you can't tell, I've been right up there reading hundreds of pages every day. So the reason that it came to you tonight is because when anybody, for any reason, seeks a special exception in this county, the UZO specifically says that the administrative officer has to make that determination report to the APC Executive Committee, who then needs to take a look at it and say, how does this fit with the comprehensive plan for the county? So it's not simply a question of, does the UZO allow this as a special exception use in our county or not? It's really a question of, how does it fit with the comprehensive plan? It's more technical. If the question was just, does the UZO allow this? Well, the BZR already does that for you. They use the 21S form. The very first question on the 21S form is, does the UZO allow this as a special exception? So sort of procedurally, the reason that we wanted this to be discussed at the meeting tonight is because it is something that the UZO requires when somebody is seeking a special exception, and it has separate meaning by the rules in the UZO as to what sort of the thoroughness and the determination should be there. And then the other thing, tying back to the Rogers Group, is we did make requests separate from just the attorney to have public comment on that portion of the meeting tonight, which were all shot down. But for the record, I'd like to say, if you look at the 2017 minutes from September on the Rogers Group mining, you did take public comment before you voted yes or no on does this fit with the comprehensive plan or not. So just sort of procedurally speaking, I know you don't see it often because it's like, who cares about an Airbnb or about an agricultural rental hall or whatever. But when you look at probably the second biggest special exception that your county has ever had go through the BZA, that's why we were trying to say, hey, sit up, look a little more closely at this, because this is a really big deal, not just to us, but it should be for you too. I spent a couple weekends ago looking through 10 years worth of the BZA's special exception work, and the only thing I could find that was even remotely close to using this much land was the Rogers Group. So that's why I keep pointing to you to that and saying, you know, think about those procedures, use those procedures, but that's sort of the behind the scenes why. There were a lot of folks here tonight, why we've been pushing and saying, take your time with this. Rainbow Trout has been working on this for 5 years. They've been with the electric company since 2020, getting permits and contracts in line to come into our county and put this project in. We're asking you to take more than 2 months to look at the application. So that's why there are a lot of people reaching out, a lot of people asking, a lot of people saying, can we do what we've done before? Because the county deserves the time. Just like the company got the time, the county and the citizens here deserve the time to think about the project.
Very good, thank you.
I'm just going to say one comment.
Sure, come on.
Carrie Earsman, 441 Kerber Road, West Lafayette. To speak to how long rainbow trout and solar has been in our county, I have a letter from Shelby Ruffner of Rainbow Trout. It is postmarked 17 May 2025 of this year. That is the first and only time that I have ever been given any notification that there may be a large-scale solar installation touching my mailbox. So I just don't understand why this is being rushed when they've been in the county for 5 years? 5 years? So, thank you.
Very good, thank you. Anyone else? Citizens' comments?
Kenny McClary, 942 Chepstow Lane. Thank you again for just a brief comment. You can see there's an apparent concern about the rush that is being pushed on this project. And there can only be one reason for that rush, and that is because it's federal subsidies which allow it to go forward and the last grasp potentially for those straws. But it's not the business of county government and county ordinance organizations to respond to something that a petitioner might need to rush for their own profit at the impact or negative aspects to the county itself. And that's a situation we find ourselves in, and that's why so many people are concerned with what appears to be a rush forward. To be able to quote a U.S. congressperson from a while back, this is not a situation where we need to approve the bill now so we can figure out what it's going to contain later. And I hope that as we go forward and as we prepare for the BZA, we realize that there are still many issues and also many aspects of deficiency which need to propose. I do have a question, Amanda. You said there is a process where the APC would reconsider their recommendation, which you read today. What is that process?
I wasn't here, but I don't know.
She mentioned it, but she mentioned there is a process where the APC
Like I
would
mentioned, I don't
reconsider
think this is a
their
question and answer session,
recommendation
so
to you.
you get your opportunity
All right.
to make your comment.
Well,
and then-
I would put it on the record then, and it would be, I'd be interested in finding out what that process is for the APC.
Okay,
Thank you.
very good, thank you. Anyone else wishing to make comments? Hearing none? Oh, come on, we got 2 minutes left.
I'll make this quick. John 8, 8640 West, 125 North. As I mentioned last time I got up here, I think the other thing that, one thing that I think confuses our community some is that as we've seen this filing on this project, as we read into it, there's no agreement for the power to be taken. There's no electric agreement to be sold yet, and yet somehow we feel that this is a project that should move forward. That wouldn't seem in a layman's mind that that is a completed project when it comes to filing for the right to move forward. The other thing that I mentioned last time that there's still plenty of activity on is that the new administration and the new Farm Bill, as well as in the great new bill that they're trying to pass that went through the Senate or went through the House, It does have specifics to defunding and regulating at a higher level current solar projects, and also limiting international ownership and qualifications that they must have, to be funded with any federal funds. So I just want to make sure that we put that back on the record. Thank you.
Very good. We have 1 minute left. Any final comments from anyone? Hearing none, I'll take that last motion.
Move to adjourn.
We're adjourned. Thank you, everybody.
Jerry, I was thinking the other day about you because, so we just moved back here 2 years ago at the home place. I kept seeing, I said,